motion for two Illinois Supreme Court justices to recuse themselves in hearing a challenge of Illinois' gun ban has been denied. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And you can see, as we reported out on Saturday morning after seeing this drop late Friday, the two Illinois Supreme Court justices, Elizabeth Rochford and Mary O'Brien, denying a motion for them to recuse themselves, and the court as a whole denying a motion for them to be disqualified. So some background here, of course, with what we've been doing each and every morning is tracking all of the litigation against Illinois' gun ban that was put into place January 10th by Governor J.B. Pritzker. And all of the ins and outs of the legal fights that have been going on, not just in federal court, which we'll get you an update there, but also in state court, where you had 4 cases, 3 from Attorney Thomas DeVore, which we'll actually talk with after 6:40 this morning, so stay tuned for that. Also, you've got a case out of Macon County that was brought by State Representative Dan Calkins. And the first case from Accuracy Firearms that DeVore had, it was decided that they would likely advance on the merits of the case about the equal protections challenge that they brought forward. And they got temporary restraining orders issued for thousands of plaintiffs that are named in those lawsuits, not for the state, but just for those plaintiffs. So Accuracy Firearms was appealed. The appellate court sided with the likelihood that they would succeed in the merits of challenging the law on equal protections. The equal protections argument is the one that says you can't give certain classes of people certain constitutional rights because the law carves out law enforcement, retired law enforcement, and others in the security industries that aren't having to comply with the law. So they're exempt from having enforcement against them, and they can go out and purchase certain types of semi-automatic weapons, but just the regular person can't. And the argument is you can't separate classes of people per constitutional rights and whether or not they're able to exercise their constitutional rights. So on the state level side, the appellate court said, hey, they're going to have a likelihood of advancing their case on the merits. So when you had several other cases kind of fall into place, again, 2 out of Effingham, 1 out of White, and then 1 out of Macon County, the Macon County case, separately, there was a motion to try to consolidate these 4 state-level cases. That did not get accepted. But the Macon County case from Dan Calkins, a judge issued a final judgment, and then it went straight to the Illinois Supreme Court. Well, then some sleuths on the internet, including Mom at Arms, a blog that goes through a lot of Second Amendment stuff, they delved deep into campaign contributions for Supreme Court justices, and they found Governor J.B. Pritzker gave 2 justices, Rochford and O'Brien, $1 million each before they were elected in November of 2022. But it wasn't just Pritzker. It was also Illinois House Speaker Emanuel Chris Welch that gave 6-figure donations to these justices' campaign funds. And that's raised the question of, conflict of interests and whether or not justices should recuse themselves. If you recall, we had that video where I asked the governor if these justices should recuse themselves, and he said, that's ridiculous. But ultimately, we had a motion that was filed by Calkins' attorney, Jerry Stocks, an official motion to have these justices either recuse themselves or to have the court disqualify them from hearing the case. Well, late Friday, they did indeed file their motions, or their orders, rather, in that particular motion. So if you take a look, you can see the orders on the Illinois Supreme Court's website. And the one from Elizabeth Rochford, it goes into talking about, trying to answer the questions of, were these contributions unreasonably large campaign contributions that could undermine public confidence in the judiciary? And Rochford said that contributions to my campaign committee might appear as counsel or parties before this court does not require my recusal from this case. Our Supreme Court rules specifically allow a judicial candidate's campaign committee to solicit and accept reasonable campaign contributions and public support from lawyers. Goes on to say that Previous precedent cautioned the court that they must consider whether attacks on a judge's impartiality are simply subterfuge to circumvent anticipated adverse rulings. Plaintiffs cast sinister aspirations that contributions to my campaign committee were made to influence the instant litigation. Plaintiffs provide no factual basis for those aspersions, she says. She goes on to say, despite the broad claim that she pledged support for gun control groups' efforts, she says plaintiffs do not cite any instance in which I voiced such support. In fact, I've made no public statement committing or appearing to commit to reach a particular result or rule in particular ways. But others are pointing out her being shown with gun control advocates, even holding up cookies with certain groups' names on it and various pictures of them at various events. So interesting to see this. But you also had O'Brien. She too denied a motion for recusal, saying because plaintiffs have failed to sufficiently plead any facts that would require disqualification, I'm required to hear and decide the instant appeal. The Supreme Court as a whole said because disqualification in this court is a decision that rests exclusively with the determination of individual judges, appellees' requests that the courts disqualify Justices Rochford and O'Brien is denied. So again, you've got that particular thing playing out late Friday. And I did reach out to Jerry Stocks, the attorney for Dan Calkins, to get a statement, and he said ultimately each justice must make an independent evaluation whether a party to appeal seeks that evaluation or not. In this respect, the suggestion that a movance raising the issue that we had a burden of proof to show actual impartiality on the part of the justice is a contention with which we disagree. The decision has been made, and we turn now to the merits of the case and the challenge that the facially unconstitutional law it's premature to determine the remedy, if any, for the participation of the justices, in our view, if it is indeed to happen there. So that's Jerry Stocks' response to the filing late Friday of the justices recusing themselves. So I did reach out to State Representative Brad Halbrook, who actually asked that question of Supreme Court's Chief Justice Mary Jane Teese, and if you remember, that was during an appropriations hearing, and she said that she didn't want to comment at that time. So she didn't comment at that time. But Hal Brooks asked if they would do the right thing. Well, I reached out to Hal Brooks Saturday, and he gave an initial reaction to what this looks like.
Yeah, well, in short, it's disappointing. The optics doesn't look very good. This just lessens the amount of trust that people place in government and in the judiciary.
And you also talked about what the next steps here could be.
Well, hopefully the Illinois Supreme Court will utilize the Constitution, and hopefully I think the 4+ U.S. Supreme Court cases will rule the day at the federal level.
So ultimately, he does have some consideration for what it's going to ultimately play out as in the Illinois Supreme Court when this is heard in mid-May. But again, he defers to having more faith in the federal challenges that could go all the way to the U.S. Supreme Court.
Correct. Yeah, I mean, the Second Amendment. There is language in the Illinois Constitution. However, I believe that it will ultimately fall at the federal level based on the cases that have come out of the U.S. Supreme Court over the last several months and years.
So again, the Illinois Supreme Court justices denying their motion for recusal in that gun ban challenge, and we obviously will have a lot more to talk about this particular issue and what there could be as far as remedy. Maybe the Judicial Inquiry Board we heard a little bit about. Got to delve deeper into that process, but you also have the issue of if they do hear the case, what kind of remedy is there after that? Jerry Stocks seeming to hint at that a little bit with his statement, saying it is premature to determine the remedy, if any, for the participation of the justices if our view is valid, that there is some questions of impropriety there. So another turn of the page here, and the latest for you this morning with Springfield's Morning News. I'm Greg Bishop on WMA.